Good morning, afternoon, or evening. Your video is about to start. I wanted to remind you of our newer Wednesday, 1 p.m. live stream Q&A on all things Social Security. Visitors are welcome to post a question in the chat, and I'll do my best to answer it. It's on a first come, first serve basis, so please get there on time. Otherwise, if you care to be a member and get some different kinds of perks, feel free to click the join button below or just click it to learn about them. Anyway, I hope to see you Wednesday. If not, enjoy the video. Bye now. Hey guys, I am looking at a response from a congressperson on a case. This is a Georgia case. And I just wanted to go over congressional inquiries and when we use them and when we don't use them, and just show you how this is a typical response. It's good. So let's get into it. Congressional inquiries, I know some people use them when they're not pleased with a response to something or like something of substance, such as I didn't like the report of the CE, or I didn't like the decision and I've been denied and it's wrong, wrong, wrong. And they think the avenue is to go to their congressperson and get him to intervene in the substance of the case and the determination. And that is not how they work. I know I've discussed this before, but they are extremely useful for other things. These are things where you're not trying to get someone to press the finger on the scale of your case, contrary to the evidence, or the objectivity and uninfluenced adjudicator or ALJ. It is for things that are more procedural. This is how I see it. Things that are more procedural. For instance, you filed and you haven't heard from anybody, and it's anybody. I mean, you may have gotten confirmation that your application was processed, and the SSA sent you a letter, and then what is supposed to happen after that point is that it goes up to the medical office for a medical workup by an adjudicator, and that's where all the real meat occurs, right? And you haven't received anything and it's 3 months later. I think 3 months is too long. I think that's an appropriate time to contact a congressperson. We know largely that the reason why it's 3 months is because there's probably not an adjudicator on that claim. They are understaffed, and I suspect that they have to wait till a particular adjudicator, whichever one it is, reduces their load by having made some decisions, and then they can be replaced accordingly. That's my guess. I haven't been up there, but that would make sense to me. So if you've been 3 months without an adjudicator, it's not that anyone is doing anything wrong, but it is not necessarily an inappropriate time to contact the congressperson. What he's going to do is simply poke the SSA and say, hey, John Doe here, my constituent, uh, says he hasn't heard anything in 3 months. What's going on, you want to make sure it hasn't gotten dropped in the cracks, right? That you know, stranger things have happened where a case just disappears. So don't know how it happens. It's not common, but it could. So then you would have to know, because you're going to have to submit a new application and preferably have proof that you did it the last time so you can get that same protective filing date. So in this case, I contacted this Georgia congressperson. I get signed permission from my clients to do this on their behalf. I have actually a special form that they sign, or if the congressperson has their own release that they want the person to sign, then I'll just shoot it over to my client. He could sign it and send it back. And in this particular case, I explained how long it's been going on. I can see into the SSA's file, and I can see all the dates any documents were put in there. And when there's only been my documents, my evidence going in, my It's a form letter I do. Every time my client gets a new provider, I want to let the SSA know so they can order those records. When I say SSA at this juncture, I'm referring to the DDS. So there could be 10, 15, 20 items in there that all came up in the last 6 months, but they're all mine. They're nothing, there's nothing to suggest that an adjudicator has been in there. So then I know that there is no adjudicator. And so when that happens, that's the appropriate time to, contact the congressperson. I don't necessarily do it at 3 months, by the way. I'm just saying if you're pro se, maybe that wouldn't necessarily be a terrible time to do it, I suppose. We just keep doing our work and keep the ball rolling on everything that has to be done anyway, with the hope that they come on. But if it starts breathing down the neck of 6 months, now we're talking. I know that sounds bad, but there's only they're going to give more attention to the longer ones than the earlier ones, right? And you don't have to worry about this as a consumer, but as a practitioner, I don't want to be the one that for every single case that someone's not jumping to my snapping of my fingers, I send in a letter or I send a congressional inquiry. I think it would lose a lot of steam, and we don't really want to abuse this process. We know what the problem is. We know there's understaffing at the SSA and not at the DDS part of the SSA. And I think that is why this is happening. So, you can't go beat the dog over the head with a 2x4 when there's nothing they can do about it at that moment, right? Okay. So had gotten a confirmation from the congressperson that they received the request for the congressional inquiry. I always put in dates so they know, hey, it's been this long since it looks like anyone's even peeked at this at the DDS. We've sent in numerous things, a dozen, and it's not lighting someone up. No one's following up with what we tell them. Um, I've gotten a confirmation from them that, oh, we will look into this. Thank you. And they have some disclaimer language, and they're usually like, just so you know, we can't be changing anyone's opinion on anything. It's like, "No, we're not asking you to. We don't need that. We have a good case. We just need the process to occur." Okay, the due process, I should say. So here's an example. Got this, today's the 4th. Got this today. Dear so-and-so, dear the client's name. Because when I submit these, I say Stephanie Joy on behalf of client John Doe. And then when it asks for Social Security, I make sure it's clear it's his social because that's how they're going to identify his case. It's not going to beat their mind. Below is the reply I recently received as a result of my inquiry on your behalf. So this is the congressperson now coming back again, first confirming he got our congressional inquiry request, and now he is responding to us when he got a reply from the SSA. And he puts it in quotes, regarding John Doe, claimant, Social Security number, blah, blah, blah. Reconsideration claim unassigned. Case has been flagged with congressional interest for assignment. So, and that is from Constituent Services Representative, the Georgia DDS Constituent Services Unit, Disability Adjudication Services, unquote. And the congressman goes on to say, just as soon as I receive additional information, I will be back in contact with you. So that's really nice. He has a cute little link in there how to stay in touch with him in terms of keeping up with what he's doing. Obviously, I won't be doing that since it's not my congressperson, but anyway, I thought it was sweet. And I will be uploading this to my client portal so my client can see that his congressperson has taken action. I will say I tend to see both sides of the fence have teams that respond accordingly and appropriately and with the same speed and haste. So it doesn't seem to be a partisan thing, which is good. I think I've mentioned this before that I will tend to, if I have the information in front of me and I don't have to do too much research, I will try to find out which of the usually three potential Congress people, two senators and a House of Representatives person is on my client's location. And which of the three, if any, are up for the next reelection? And I'll use them because I figure they might be, there's less chance of someone being remiss because they, are up for reelection. Um, so notice that the language was reconsideration claim pending unassigned. So the reconsideration claim that is pending is unassigned. So we know that we are right. It's that short staffing business and it hasn't been assigned because it probably can't be. But then it goes on to say the case has been flagged with congressional interest for assignment. So I will report back when I hear the next news, guys. So if this is February 4th, how long since they got the SSA, knows that there's a congressional inquiry, congressional interest, and they see how long it is, they might bump him up because he's not, he might be maybe one of the next ones on the list now. Because I would like to think it because he's durationally out, but he might not be as old in the case as some other people, but it's been an old since he had an adjudicator. So however they're going to look at it, I don't know, but very, very useful. I just sent this, I don't know, was it last week? Something like that. It wasn't that long ago. So I was very pleased to get that, and I look forward to sharing it to my client. It's these little wins sometimes, guys, that because I could continue to send like I was sending, every 2 weeks another letter, blah, blah, blah. It wasn't doing anything. It usually does do something, and I don't have to bother a congressperson or any of that, or become the person that always sends out congressional inquiries. I mean, for people up here, we don't want to be Karens. Um, always saying our clients need to get in front of the line. No, that's not going to happen. Not on my watch anyway. But when it's getting old and there has been stuff to go in. Now, let's say my client really had been falling down on the job of getting treatment, wasn't really doing much. There was nothing much to send up. I might not be rushing this because I will be nagging him. You've got to go do this, or else your case is going to fall down the tubes. And if it does, because you're being slack, I might have to withdraw because I expect someone to take action if they're able to on their own behalf. Um, that's not this case, obviously, and that's very rare with my clients because I'm kind of all over them like white on rice. But occasionally it happens, but this isn't one of those cases. So we definitely we got all the stuff in. We've been getting it continuously. When that adjudicator gets assigned, he or she's going to have plenty to do, and that's golden because the alternative is they don't have anything to do and they make a decision based on nothing because the attorney didn't send anything in. They would probably reach out and say if anything's no, and I expect them to do that anyway because it's probably a canned letter when they come in on a existing case that's been out there for a long time. But fortunately, we've been putting everything in, so I can just make a quick phone call and say it's all there. Look at those letters. That's all the new providers, all anything new major coming up. Blah 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 blah. Okay, all right. So congressional inquiries, awesome, awesome, awesome for a situation like this. So do use them. Just don't try to use them to alter justice in your favor in terms of the merits of your case. If your case is strong, that shouldn't be necessary. That's the theory anyway. All right, guys, I'll talk to you later.